The court's going to take up the next case on the court's docket, CV 2003113. This is in the interest of Ian Woods and Jaden Woods, children. The case is set for a bench trial on a petition filed by the Texas Department of Family and Protective Services. A hearing today is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the hearing today on behalf of the department is to engage case manager Haley Smith, supervisor Crystal Gillette, and Brown County Attorney Shane Britton. The mother of the child is Julie Alvarado, and she is participating in the hearing today with her attorney Patrick Howard. The father of the children is Danny Woods, who was personally served with citation notice suit on March 11, 2020. I don't believe Mr. Woods is currently present. The court has appointed Emily Miller as his attorney ad litem, and Ms. Miller is present. The attorney and guardian ad litem for the children is Chelsea Timmons, and Ms. Timmons is present, and the children are excused from participating in the hearing today. As I noted, we're set for a bench trial today. Mr. Britton, is the department ready to proceed?
We're ready, Your Honor.
All right, Mr. Hart, are you ready to proceed?
We're ready.
Ms. Miller, are you ready to proceed?
I am, Your Honor. Thank you.
And Ms. Timmons, are you ready to proceed?
Ready, Your Honor.
All right, is anybody invoking the rule?
No.
No.
No, Your Honor.
Okay, thank you. The rule is not invoked. Any opening statement from the department?
No, Your Honor.
No.
Any other things from anyone else? Okay.
No.
Everybody's waiving opening. Okay, thank you. Let's see. I'm going to go ahead and swear in who I anticipate might be witnesses. Ms. Gillette, Ms. Smith, and Ms. Alvarado. Could each of you raise your right hands, please? Each of you solemnly swear or affirm any testimony you give today before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. All right, Mr. Britton.
I'll call Ms. Smith, Judge.
Okay, thank you. Go ahead.
Haley, you are the permanency case manager for To Engage.
Yes, sir. That's correct.
And you have been working with Miss Alvarado as it relates to the Woods children, Ian and Jaden.
Yes, I have.
My understanding is that Miss Alvarado has done wonderful in this case.
Miss Alvarado has done remarkably well. Yes, sir.
And you are prepared to recommend to the court that the court enter a final order naming her as the sole managing conservator of the children.
Yes, that's correct.
Now, as well as the mother has done, the father's kind of the opposite.
That is correct.
And he's just kind of disappeared and really hadn't shown any interest in really doing anything in this case.
He has not. Since he was asked to leave Julie's residence, I haven't had any contact.
When he was, I'm sorry, you kind of broke up. He was asked to leave what?
When he was asked to leave Julie's residence at the,
Okay.
then haven't had any contact with him at all.
Okay, all right. And so you believe that it would be in the children's best interest to name their mother as the sole managing conservator and their father as a possessory conservator, and all possession and access to the children by the father would be at the mother's discretion.
Yes, that's correct.
If she thinks it's appropriate, she can allow it. If she doesn't think it's appropriate, then she won't allow it.
That's correct. There is a protective order, so I just want to make sure that she remembers that so she doesn't violate that if he does come around.
I think she'll probably remember that.
I think so.
I'll pass the witness, Judge.
Mr. Hart, any questions?
Ms. Smith, I think you stated it, but really mom's turnaround in this case started when the father, unfortunately, moved out of the house.
Yes, that is correct.
Okay. And since that period of time, she's really been a perfect CPS mom.
She's been wonderful. I agree with that.
Okay. And part of the credit of that goes to you continuing to work with her. That's true. You know that's true.
She's taken a lot of credit. She's admitted her faults and she's worked really extremely hard.
Sure, but the dad didn't leave at the beginning of the case. He left somewhere in the middle of the case.
That's correct.
And at that point, mom wasn't doing very well, was she?
No, she wasn't.
And so if this is a case where we just said, hey, you've had your chance, we're not going to keep working with you, she probably wouldn't have been successful.
You're probably right.
Okay. But since that period of time, she's has a job, she has a house. I don't want to take up too much time, but I do want to express to the court how well she really has done.
She has done well. She's completed all of her services. She's got a good job. She just got a pay increase. She works very hard. She's really done remarkably well.
And she's also developed a support system. Isn't that true?
That is true.
And you'll be part of that support system, right?
I told her she can still contact me if needed. We went over a little plan yesterday and she's got some people in place if needed, but I told her that if she ever need anything, she's more than welcome to reach out.
So this case is going to have a good result that way as well. So we're just not going to leave her. We're going to continue to help her as it should be.
Yes.
Okay. I don't have any other questions. Thank you.
Ms. Miller?
Thank you, Your Honor. Ms. Smith, you had some relatively unpleasant dealings with Mr. Woods earlier in the case, correct?
Yes, ma'am, that's correct.
Okay. And when was the last time that you had either phone or text or physical contact with him?
I haven't had phone contact with Mr. Woods since about November of 2020, and I ran into him at a local restaurant about the first of the year. I think it was around January, and I left him with my card, but he still had not reached out to me. I have attempted several times to contact him on the number that I have with no success.
Okay. And you understand I've fallen out of contact with him as well.
Yes, ma'am.
Okay. And if you had, or if you receive any time in the near future, any updated contact information on him, would you please share that with me?
Absolutely.
All right. Nothing further, Your Honor. Thank you.
Thank you. Ms. Timmons, do you have any questions?
Thank you, Your Honor. Ms. Smith, have you had the chance to watch Miss Alvarado and the children interact?
Yes, I have.
Okay, and is that all appropriate?
It's very appropriate. Both boys are very attached to mom. They actually don't like to leave her side. They have very appropriate interaction.
Okay, very good. And I think you already asked this, but the home is appropriate for the boys to be in?
The home is very appropriate. Yes, ma'am.
Okay, very good. Thank you.
Let's see, Mr. Britton, did you have any other questions?
I had nothing further, Judge.
Any other questions for this witness? From anyone else? Ms. Smith, regarding Mr. Woods, are you aware whether he has any other children under the age of 18 besides these two children?
I'm not aware that he does, no.
And do you know of any reason why he can't pay child support?
I'm assuming he doesn't have a job, but there's no reason that he could not have a job or pay child support.
Is the department making a request that the court order child support for?
Yes, I think that would be appropriate.
Your Honor, if I may interject, I've represented Mr. Woods in a previous child support matter, so I am aware of there being one child under the age of him having one other child under the age of 18.
And so as an officer of the court, you're representing that you have knowledge of him having one other child under the age of 18?
Yes, Your Honor, most definitely.
Okay, thank you. I appreciate that. All right, any other questions for Ms. Smith in line with the court's inquiries? Thank you. Any other witnesses from the department, Mr. Britton?
No, Your Honor. Nothing further.
Thank you, Mr. Howard.
I'll call Ms. Alvarado for a couple questions.
Okay, thank you. Go ahead.
You're Julie Alvarado, is that right? You hear me? Okay.
Yes, I hear you.
Okay, so Ms. Alvarado, we're at the end of this case, I hope. You agree with everything that Ms. Smith testified to?
Yes.
Okay, and I know you don't have a good, doesn't seem like you have a good Wi-Fi there, so I'll go quick on this, but you're asking the judge to name you as sole managing conservator of your two children.
Yes,
And you think that's in their best interest?
absolutely.
And you also believe, based on everything the judge has heard in this case, that you need to be named sole managing conservator.
Yes, sir.
As far as Mr. Woods goes, have you heard anything from him recently?
No, sir. None at all.
Do you believe that there may be a reason for you to have to, unfortunately, to limit his access to the kids?
I mean, I haven't talked to him, so I mean, no. I mean, I don't. I mean, I'm just doing what I have to do for the kids, pretty much.
Sure, but based on what you knew about him when you were in contact with him, is there a feeling perhaps that he wasn't doing good at that time, was he?
No, sir.
Okay. And so you're asking that the court name him possessory, but put all visitation at your discretion.
Yes, sir.
Is there still a protective order involving him protecting you?
Yes, sir.
Do you know
There
when
is.
that expires?
No, I don't have my records with me, but it was a 2-year thing.
Okay. But you intend to follow that as far as that goes?
Yes.
Okay. And so, Ms. Alvarado, I guess does he have any other kids besides that one that was mentioned earlier?
I'm sorry, you broke up on me.
I'm just asking, does the father have any other children besides that one other that was talked about earlier?
Yes, he has a daughter.
Okay, just one other daughter?
Yes, that's it.
Okay. All right, Ms. Alvarado, I'm gonna let you go. No further questions.
Thank you, Mr. Brittany. Any questions?
No, Your Honor.
Ms. Miller?
Yes, Your Honor. Thank you. Ms. Woods, you and I have been acquainted for years now as a result of my representation of Danny. And congratulations on your success.
Yes, ma'am.
And if I understand that you're out of touch with Danny, as am I right now. If you receive any updated contact information from him within the next month or so, would you provide that to Mr. Patrick, or would you contact me with that information?
Yes, ma'am, absolutely.
Okay. All right. Nothing further, Your Honor. Thank you.
Thank you, Ms. Timmons. Any questions?
No, Your Honor.
Thank you. Mr. Howard, any other witnesses?
I don't have any other witnesses. I'm not sure if Mr. Britton asked, but I'd ask the court to take judicial notice of the court file and all the documents contained therein.
Is there any objection in court taking addition notice of the contents of the court's file for purposes of the hearing?
No, Your Honor.
No, Your Honor.
Right.
No
Court will then take judicial notice of the contents of the court's file. Right.
We have no other witnesses, so we'll rest.
Thank you. Ms. Miller, did you have any witness you want to call?
No, Your Honor. Thank you.
Ms. Timmons?
No, Your Honor.
Okay. All parties rest in closing.
We do, Your Honor.
Any closing from anyone?
No.
Ms. Timmons, as attorney and guardian ad litem, are you in agreement with the orders requested by the department as being in the best interest of these children?
I am, Your Honor.
Thank you. All right, y'all stand by for just a second. All right, the court, after hearing the evidence presented and after taking addition notice to the court's file as noted on the record, and after hearing the recommendations of the attorney and guardian ad litem for the children, is going to make the following findings and the following orders. The court finds that a request for identification of the court of continuing jurisdiction has been made as required by law, and that that this court has jurisdiction over this action and no other court has jurisdiction over this action. Y'all stand by for just a second. Okay, sorry for the delay. The court finds that all parties entitled to notice have been notified The court finds it would not be in the best interest of the children for the respondent father, Danny Woods, to be appointed as a managing conservator of the children because such appointment would significantly impair the physical health and emotional development of the children, and that any such presumption is rebutted. The court finds it would be in the best interest of the children to appoint Julie Alvarado as sole managing conservator of the children with the exclusive right to designate the primary residence of the children without geographic restriction and with all the other rights and duties of a parent sole managing conservator under applicable law. Court finds pursuant to sections 153.004, 153.191, 153.192, and 153.193 of the Texas Family Code that the appointment of the respondent father, Danny Woods, as a possessory conservator of the child would be in the best interest of the child, but that any presumption that the respondent father should have rights of possession and access to the child pursuant to the standard possession order is rebutted. The application of the standard possession order to the facts and circumstances of this case is unworkable and inappropriate, and that the limitations on rights of possession and access to the children by the respondent father, Danny Woods, do not exceed those necessary to protect the best interest of the children. The court further finds good cause not to order specific periods of possession and access to the children by the respondent father. The court finds the respondent father has an obligation to support the child and that the respondent father should be ordered to pay child support to the respondent mother based on the minimum wage presumption for two children with one other child not before the court to support. And the court finds it should enter orders for the medical support of the child, or the children, excuse me. The court will therefore enter the following orders. The department is dismissed as temporary managing conservator of the children, and the mother, Julie Alvarado, is appointed as the sole managing conservator with the rights and duties noted earlier. The father, Danny Woods, is appointed as a possessory conservator with his visitation to be at such times, places, and under such circumstances as agreed by the sole managing conservator. The respondent father is ordered to pay child support based on the minimum wage presumption for two children after giving him credit for one other child not before the court. And that to start on August 1st, 2021. Child support would be subsequently stepped down to child support for one child based on the minimum wage presumption when one of the children is no longer subject to a child support withholding order. The court will also order cash medical support of $25 per child to be paid at the same time as the child support, and to be terminated as provided by law as to each child as the children are no longer subject to support orders. The child support and cash medical support to be paid to the Texas Child Support Disbursement Unit. The respondent mother will be responsible for obtaining health insurance and dental insurance or enrolling the children in applicable government benefit programs and that provide such coverage. And the respondents will each pay 50% of any uninsured medical or uncovered health and dental expenses of the children. The court will discharge, with the court's thanks, Mr. Howard, Ms. Miller, and Ms. Timmons from their appointments 31 days after entry of a final order by the court, reflecting the findings and orders announced by the court today. The court gives notice to the parties and counsel the right to appeal the court's findings and orders pursuant to section 263.405 Texas Family Code, and the right to request a de novo hearing before the referring district court pursuant to section 201.015 Texas Family Code. The court gives notice that an appeal in suit which termination of the parent-child relationship is sought is governed by the procedures for accelerated appeals in civil cases under the Texas Rules of Appellate Procedure, and that a failure to follow the Texas Rules of Appellate Procedure for accelerated appeals may result in a dismissal of the appeal. The court will sign a final order that's consistent with that. The findings and orders of the court reflecting the judgment of the court today. Ms. Alvarado, When we have a case like this, our result is that we desire to have the children back with the parent. I'm happy that that's happened in this case, and it's due in large part to your efforts in this case. And I encourage you to keep doing what you've been doing, and I wish you and the children the best of luck. With that,